On the bail decision, this one's a little tougher because you generally don't interact with defendants at bail hearings. I mean, it's pretty rare, in fact, and instead, what you're really doing is interacting with the lawyers. But I think it's important to explain, not for the purpose of the defense attorney, they know this stuff, but to explain for the defendant's benefit that, look, what I have to consider here is the likelihood of you coming back to court, the likelihood that you're going to commit a new offense while this case is pending. And in our county, we have a risk assessment tool that gives me information about what risk you pose on those two factors. Now, I also can consider as part of that, public safety. So, that's why we ask about how many prior cases you have, were you out on bail in this case? Did you ever fail to come back to court before? What are your ties to the community, job and residence? And do you have a drug problem? And so I want to know those things so that when I set bail, and more importantly than the amount of bail, are the conditions of release and supervision conditions, so they're tied to you as an individual, and that's why we're doing the things we do. And if you have any questions about that, you can talk to your lawyer about it. If you have concerns about being on a GPS monitor or a scram bracelet. So if I just say to somebody, sir, I'm ordering as a condition of your bond that you wear a scram bracelet. I go, what the hell's a scram bracelet? And so I have to explain, well, it's a bracelet you're going to wear that tells us if you're drinking electronically. So if you drink, it's going to send a message, a electronic signal to the computer at the monitor's office, and we'll know that you've had something to drink. That'll be a violation of your bail. So explaining those things, or that the GPS, if you put them on GPS and you have an exclusion zone or inclusion zone, explaining that is important. I start out a sentencing decision with telling them what I have to consider, and then addressing each of those factors, and then arriving at what I think is the appropriate sentence. Many times, depending on the nature of the case, I'm trying to think in 21 and a half years whether I've ever not done this. When the defendant is talking to me and telling me things, I will have a conversation with the defendant and ask them, okay, so you told me this was going on, or that this was an issue, what's going on here? What happened with that job? What happened with this? The last time you were on probation, you got revoked. Why is that? You've been through batter's treatment before. Why did this domestic violence happen? Asking a defendant, well, this didn't work. The strategy we used last time you were in on this case didn't work. What do you think? And you got to be careful with this one. But I've asked defendants, what do you think I should do? But you have to set that up and say, look, I'm not telling you I'm going to follow this. I'm still free to do what I think is appropriate, but I'd like to hear from you what you think is appropriate. What do you think we need to do to address this? Now, I'm not going to do that with a guy who I'm sending to prison for 150 years, because it's a pretty rare bird, even in those cases, that says, "Judge, lock me up for the rest of my life because I'm a danger to the community." Right? There have been some that say that, but not very many. So I think it's only appropriate where you're really considering a community-based sentence. Now, I have said in the past, look, sir, I'm considering, 12 months in the county jail, but that's going to be a straight-time sentence. No release privileges. They're not doing any programming there. You're just going to sit for 12 months. Or I can send you to prison for 18 months or 15 months. And the difference there is two things. One, they have programming there that you can get into. Two, they will move you into a halfway house fairly quickly with that short a sentence, where you may have release privileges to the community or for treatment or for a job. That's not up to me. That's going to be up to the Department of Corrections as to when they move you. And they may not move you at all. You may sit in the prison for the entire 15 months or 18 months. You may not get any programming. You may not qualify, but there's at least a possibility. what do you think I should do? Every time I've done that, the person has asked for the prison sentence because they believe, right or wrong, mostly right, that they're going to get some opportunities in the prison system that they're not going to get in the county jail. Now that's changed since I used to do that, because now we have a new superintendent of the House of Correction who's big on programming and has brought a lot of those kinds of progressive sentencing alternatives or program alternatives to the House of Correction. So now I wouldn't do that. And the other issue is our sentencing structure changed from an indeterminate sentencing to determinate sentencing. So it's less likely that I would have or any judge would have a scenario. But, I don't think it's a bad thing to ask defendants, what do you think I should do? What do you think, what do you need why do you keep coming back here? On the neutrality issue, I think the biggest problem in our system, in any system, are the fact that DAs are assigned to courts as a team, so they're in here day after day. The defense bar is not that big for our community, and in order for them to function and make a living, they have to do a high volume of cases. So they're in the same courts day after day. They're friends with the district attorney, or maybe they're friends with the judge, or at least they know the judge well enough to say hi. So if you come in here and I start talking to you about what'd you do this weekend, or you're watching, Breaking Bad, or whatever you're doing, or did you watch the football game or the basketball game, or we're telling jokes, even appropriate jokes, to you and I up here, it's good morning, it's a normal human discourse. But to somebody out in the gallery, especially with this security wall we have, they can't hear what's going on. What do they see? They see two people who seem very friendly towards each other, who are laughing and joking or engaging in a friendly conversation, whether it's the judge and one of the lawyers, or the judge and both lawyers, or the two lawyers, the DA and the defense attorney. We already have defendants who come in all the time and they say, I don't want a public defender, I want a real lawyer. Right? Or they want a lawyer who's not paid for by the state, which public defenders are. Or they want a lawyer who's going to fight for them, and they see a lawyer who's 2 minutes before being real chummy with the district attorney. And that isn't just the interaction between the judge and the lawyers, or between the two lawyers. It involves the court staff, because I have often said that the most important person in the courtroom is the person sitting to my right over here, the clerk in the courtroom, because he or she is really the face of the court and the person that many people who come in the courtroom have the most contact with. And so if she's surly or grumpy or prejudiced, none of those things, of course, apply to this clerk who's in this courtroom. She's terrific, seriously. But if she presents that kind of an attitude, people will walk out. They won't walk out saying that clerk is this or that kind of person. They'll walk out saying that courtroom is, I don't want to go in there. And the same thing is true for the bailiff. So again, a judge has to make sure that their staff is acting appropriately, not telling inappropriate jokes, not being demeaning to, domestic violence court, victims drop out of prosecution all the time. And if a clerk or a bailiff says, here we go again, that victim didn't show up, his case is being dismissed, what else is new? What is that message does that send to everybody in the courtroom? So I think judges have a responsibility to have a conversation with the rest of their team, and it's got to be viewed as a team, and say, look, we're all in this together. This is how we present to the world, or to at least the people coming in here, and we need to be careful about that. If we're talking about procedural fairness and people understanding what's going on and accepting the legitimacy of court proceedings, all of the things we've been talking about are just as, or almost as important to the people in the audience who are connected to this case, or maybe just have their own case coming. And so if they hear these kinds of explanations, a couple of things happen. One, they, I think, view the system as more legitimate. And secondly, when they come in for their case, or their family member comes in, they're hearing it for a second time, and it makes more of an impact. It may seem to an outsider, well, this is frustrating, just get the hearing done. This is just going to slow things down. The reality is it speeds it up because we're only going to do it once if we do it right. Why is there always time to do it over, but not enough time to do it right the first time? And so, I think that should be our mantra, get it right the first time or as close as we can.